Welcome, everyone. My name is Chris Summerick. I'm Executive Director of Humanities Nebraska. So glad you could join us for the final program in our series of Valuing the Vote. We have been doing this for the last few months, and we started back in November doing a series of programs on women's suffrage. Took a break for the holidays, and then came back with some programs on the civil rights movement over the last month or two, and are culminating with this special program with Professor Keith Gaddie that I'll introduce in a moment about the Voting Rights Act. And so we're really glad that you could join us here. So this program is part of a national initiative called Why It Matters, Civic and Electoral Participation, which is funded by the Andrew W. Mellon Foundation through the Federation of State Humanities Councils. So many humanities councils across the country are doing a variety of programming around kind of civic and electoral issues at the moment. And we are just pleased to put together a program valuing the vote, a theme to talk about with Nebraskans, how the right to cast our vote has been expanded over our country's history, and often through great difficulties and challenges, and continues to require the watchfulness of our citizens. So I would like to introduce you now, and then I will get out of the way, to our moderator and our featured speaker today. So moderating this will be Jonathan Benjamin-Alvarado, a former Humanities Nebraska board member, professor, assistant vice chancellor for student affairs, and professor of political science at the University of Nebraska at Omaha. He is the founding co-director of UNO's Office of Latino and Latin American Studies, and was the former director of the UNO Intelligence Community Centers of Academic Excellence program. He recently completed his term as the chair of the Nebraska Advisory Committee to the U.S. Commission on Civil Rights. And he was a wonderful Humanities Nebraska board member and always a friendly face to have involved in our program. So thank you, Jonathan, for your time with us today. And then our guest speaker for today is our Keith Gaddie. And Keith Gaddie is President's Associate's Presidential Professor, that is a mouthful, and Executive Faculty Fellow at the University of Oklahoma, and a Senior Fellow of Headington College. Together with Kim Gaddie and Kirby Goidel of Texas A&M, he edits the Social Science Quarterly. Keith is faculty in both Christopher C. Gibbs College of Architecture and the Gaylord College of Journalism and Mass Communication. He studies the built environment and democratic values, and has a special interest in the American South. He's a noted expert on the American South, on voting rights and redistricting, and has authored or co-authored several books and journal articles on those topics. Among his published works are the books Regulating Wetlands Protection that came out in 2000, and Triumph of Voting Rights in the South in 2009, and Rise and Fall of the Voting Rights Act in 2016, which is what led us to Keith. And so we're really pleased to have him with us. He was previously professor of political science at the University of Oklahoma and chair of the department from 2014 to 2017. He served on Tulane University's School of Public Health and Tropical Medicine, and has a visiting faculty relationship with Center College in Danville, Kentucky, teaching architecture of democracy in 2015 and 2019. So, Keith, thank you for your time with us here in Nebraska today. And I'm going to turn it over to you and Jonathan, and I will get out of the way. And then I want to mention to the audience that we will be utilizing the Q&A function on Zoom. So you are able to put questions in the chat, or really in the Q&A would be best, and we'll kind of track them that way. And get your questions kind of into the mix at some point during the program. So thank you. Jonathan, why don't you take it away?
All right, Chris, thank you so very much. And Keith, so good to see you, my friend. So Keith and I share a little bit of a history together. We're both graduates of the University of Georgia, excuse me, in their Department of Political Science. And I made a joke that we're both had deep roots in the South, and I think it really lends itself very well to what our conversation is going to be about today. And in particular, I have to give a shout out to a mentor to both of us, the incredible Charles Bullock at University of Georgia, who I think his legacy extends far, far beyond the South. Actually, that we have people here in the Midwest who had both the privilege and the honor to study with him and to learn from who probably is the most well-versed individual on Southern politics in the United States today. So, Keith, thank you so very much for being with us.
Jonathan, it's good to see you and it's good to be here. And, as I mentioned before we got online, I've got some ties and connections back to Nebraska. I've spent some time up at the Unicam. So this is a particular treat for me.
Oh, wonderful. Thank you. So, but that's not what we're here today. We're here to talk about the Voting Rights Act and some of the things that animate our present political conversations about it. We wanted to gain some insights from you. So we're so very happy to have you here with us today. And I just wanted to throw a couple of bullet points out there for you to kind of maybe frame your initial comments. That we'll get about 15, 20 minutes in, and then we'll turn it over for Q&A. But I guess if you could share with the group that we have with us today, some of the questions as to why the Voting Rights Act came about. And, we focus a lot on the fight for voting rights in the previous programs that we hosted here at Humanities Nebraska. And maybe some of the things that have happened in the course since 1965 until a major Supreme Court ruling in 2013. What were the successes and some of those adjustments that led us to the Shelby versus Holder decision? And ultimately, what are the implications? And then I'll maybe have a couple of more questions to add to that. I knew it threw a lot on the table there all at once, but I'll turn it over to you, my good friend.
Well, Jonathan, again, it's a pleasure to be here. And I appreciate the shout out to Chuck. I told Kim that you should just put an ampersand at the top of my gravestone because I always come after him on all these projects, and fittingly so. It's important to remember how Congress and how the courts viewed voting rights in the 1960s and the need to address the challenges of minority voter participation in the South. The Warren Court observed that Congress felt itself confronted by an insidious and pervasive evil which had been perpetrated in certain parts of the country through very creative means. That a variety of tests, devices, what we call facially neutral restrictions have been created to perpetuate the exclusion of people of color and especially African Americans from the ballot. Most of these barriers had come into play sometime between about 1880 and roughly 1920. And it was the efforts to push back against the white primary that really drove home the nature of how hard the South would fight to defend white-only rule, a white-only electorate. The state of Texas 3 times had their white primary thrown out by the Supreme Court. And each stage of the way, they revised their law to attempt to put it back into place while addressing the defect articulated by Congress, but still keep Blacks out of political life in the state of Texas. And this fed into the response of Congress in crafting the Voting Rights Act in 1965. There had been efforts previously in the 1957, 1960, and 1964 Civil Rights Act to address the problems of Black voter participation. And every step of the way, the South had resisted, had gotten creative. To give you an example, efforts to seize voting records in the state of Mississippi led to their immediate destruction in all but 3 counties. Evidently, there was a voting arsonist at work in the state of Mississippi or some such thing. Very creative and witty efforts to defy the courts, to defy Congress. So after the Selma March and the effort to enroll voters in Dallas County and the bloody confrontation on Bloody Sunday at Edmund Pettus Bridge, you get what LBJ asked for, which was the toughest goddamnedest voting rights law that could be crafted by Nicholas Katzenbach. It took 5 months to pass that law, finally being passed into law in August. And that law really did 3 things that were interesting. It created a vehicle nationwide to be able to litigate and challenge discrimination in voting, what's called Section 2 of the Act, which still exists and is still in force. It created a coverage formula for parts of the country under what's called Section 4 to apply another part of the law called Section 5, which froze in place voting practices and compelled states or jurisdictions that were covered by Section 5 to demonstrate that if they wanted to change their election laws, they wouldn't make minority voters worse off than they were otherwise. And that provision initially covered parts of 6 states, all or part of 6 states, later on expanded itself to cover all or part of 9 southern states, plus parts of New York, parts of Michigan, parts of New Hampshire. This coverage formula is the basis for later litigation that we'll talk about, the Shelby County case. And the reason that the coverage formula was important, the reason Section 5 was important, is it turned the state-federal relation in elections upside down. The Constitution leaves it to the states to conduct elections, except in areas that Congress seeks to apply its Article 1 authority. And the implementation of Section 4 and 5 of the Act was essentially an extraordinary emergency provision, because the South was consistently acting in bad faith. No matter how quickly the courts could overturn a discriminatory law, another one would pop up, and you were playing whack-a-mole against an opponent who could regenerate far too fast. And so this act is designed to freeze that in place, to put registrars into the South, to get minority voters registered to vote, to get rid of discriminatory laws, to get rid of tests and devices like literacy tests that were applied in an arbitrary fashion. And the immediate impact was you had a substantial increase in minority voter registration. You had an increase in conjunction with redistricting reform of the election of minority representatives, representatives of choice to the legislatures. But it would still be, well, actually it would be until the election of Barack Obama that we'd see African-American and Anglo-white voting rates in the South become equivalent. So long answer, sorry about that.
That's quite all right.
Yeah.
So what, one of the things that it strikes me then, so how do we get to the point where Shelby versus Holder then becomes a salient issue? Yeah. And it is, and then is sent up to the Supreme Court for adjudication? Okay,
so laying this out briefly, I mentioned this thing called Section 4 of the Act earlier. That was what was called the coverage formula, or the trigger. And it's an example of what's called a sunset law. It was a law with a limited time period to apply, and then Congress would either have to reauthorize it or it would expire. And that is what allowed Congress to craft this statute that turned election administration upside down. It was an emergency provision. So Congress implements the Voting Rights Act. They put into place a coverage formula for 5 years. In 1970, they come back, they revisit the coverage formula, and they update it. And what they do in particular is the way the trigger worked, it had two conditions. One was that you had to have less than half of the potential eligible electorate, adult electorate, either registered to vote or voting initially in the 1964 election for president. And you also had to have use of some form of test or device, which could include English-only language ballots, okay? So the Act initially picks up the Deep South plus part of North Carolina. When the trigger is updated in 1970, it expands coverage, picks up part of New York State in particular, 3 boroughs of New York. And then when the Act is renewed again in 1972 to be applied starting in 1975, it's renewed for a period of 7 years. And the formula expands to cover Arizona and Texas, Michigan, a few parts of Florida. And so they kept updating the formula by updating the data to be applied to use the most recent election. Well, in 1982, Congress has to renew the Act again. And what Chuck and Justin Wirt and I contend in Rise and Fall of the Voting Rights Act is Congress was tired. They were tired of the issue. They wanted to make it go away for a while. So they renewed the coverage formula again for a period of 25 years to expire in 2007. But they also used the data from the 1972 election and kept using it going forward. Okay, the reason they did that is voter participation had gotten so good by the 1980 election that a lot of the South would have dropped out under the coverage formula, so they kept using the old data. What happens is by the time we get to the time to renew the Act around 2005, 6, 7, we're now using a coverage formula based upon voting behavior that's roughly 2 generations old. And the question comes up, should you update the coverage formula? I was one of the ones that testified in front of Congress saying, yeah, update the formula because there's a constitutional defect. If you don't update the formula, there's this other case that has to do with religious relics that comes out of Harris County, Texas, called the City of Bernie case, which holds you can't use old behavioral data, old information on human behavior as a foundation for crafting law. Congress can't do that. So what happens is Congress doesn't update the coverage formula because a new formula would have dropped out huge chunks of Louisiana, parts of Texas, a good bit of Georgia. Mississippi had the highest rate of Black voter participation in the US in 2005. So it creates a situation where the coverage formula doesn't look attractive to the powers that be. And it also would have expanded coverage in places like my home state of Oklahoma here, Kentucky, Tennessee, Arkansas, parts of Ohio potentially, because nearly every state in the US at some point in time had used an English only ballot. Okay. So the trigger would have broadened coverage and that would have been deeply unpopular. So Congress renews the law with the old data in place. This sets up a pair of challenges, what's called the Nemudno case in 2009 out of Texas. And then in 2013, Shelby County v. Holder, which was a test case that was funded by the same conservative activists who had been behind all the Bush v. Gore the Bush-Miller-Hayes litigation that overturned majority minority districts all over the South. And lo and behold, a signal that Justice Roberts had sent in a case called Nemudno that there was a defect in the law came true in Shelby County. And they threw out the coverage formula and neutered the most effective, powerful component of the Voting Rights Act.
So what are the implications of that then?
Well, within hours after the act had been invalidated by the Supreme Court, states started passing laws that had previously been under review by the Justice Department to make sure they weren't discriminatory. So more substantial voter identification laws were passed in several states. The state of Alabama started shutting down a lot of their early voting and motor voting facilities throughout the Black Belt in particular. You see the effort to put a lot of very clever, creative, technical rules into place related to voting. And in a way, this is an echo to what was done previously in the late 19th, early 20th century, that you start putting in highly technical provisions that voters will trip over if they're not careful with their paperwork. And it feeds into a lot of old tropes about less educated and minority voters that were actually foundational to the creation of the poll tax. And you end up creating what is effectively poll tax conditions in the South and elsewhere.
So that being stated, and given what we just saw in the last presidential election, some people argue that this is really kind of an impetus for broader voter suppression. But at the very same time, we saw record voting in places like Georgia. Why?
Well, extraordinary effort on the part of minority voters and their voter organizations, and especially the Black church, to turn out the vote. And this has been going on for a while because Georgia had been pushing enhanced voter ID since 2007. But also I think we have history to call upon, which is we've seen what happens if you don't make an effort to mobilize. And the thing to remember about what happened in the 19th century with Black voter demobilization was when these laws were put into place, they largely ratified what had become the new status quo of demobilized Black votes. That Morgan Cowser's talked about this, that intimidation and violence had largely driven Black voters from the polls, and that these laws simply locked down the status quo. You're not starting from that same baseline, but you've also got a much richer legal network to go into court and litigate these things. You have much better organization, but also you've got press on this. We're living in an age where it's very easy to get information out and organize voters. And this was part of the key of the Barack Obama campaign, was this approach to networking. And I think that's a lesson that Stacey Abrams learned really well. But it shouldn't have to be that way. Because in brief, all these laws start with the assumption that voting is somehow a privilege. And you have to demonstrate your worthiness to vote, where in fact in state constitutions and under the law, voting is deemed to be a fundamental right. It's yours, okay? And these efforts to limit it are the application of negative rights, and therefore are subject to scrutiny if they prove to be discriminatory.
So what's interesting about what you just stated, and something that I just kind of came across yesterday, you know, that old the Southern Conference, Southern Christian Leadership Conference,
Yeah.
issued a statement yesterday that calls upon President Biden to use executive order to restore sections 4 and 5 of the Voting Rights Act. How plausible is this, and what would be the implications of the use of an executive order to kind of reimpose those sections of the VRA?
I think it would get thrown out in federal court in a matter of hours because it's an application of Section 1 authority, which is the congressional authority first and foremost, okay? Second, it's an effort to correct a defect in legislation that was created by Congress. It's not an effort to correct a practice, regulation, rule, or procedure inside the Department of Justice. That being said, what can be done by executive order is directing the Department of Justice to aggressively use poll watchers and registrars in these states and assure good faith implementation of the state's existing voting rules. And I tell you, I'm going to pause and take question, but we need to talk about the incredible act of our friend Gabe Sterling in Georgia in being a good faith actor at some point. Because if there were more people like him administering elections, we wouldn't be so worried.
So we will take questions, but I would like us to maybe focus on that right now, because I do believe that was an extraordinary act that was undertaken on his part, an incredible amount of bravery. But actually, at the end of the day, he was upholding what he had sworn to do to begin with. And I think that should be the lesson that we can take away from that. But do you want to elaborate on that just a little bit more so people have a better understanding of what he did?
Yeah, well, in a nutshell, Gabe Sterling is another one of Chuck Bullock's proteges,
Yes, he is.
with the University of Georgia and Georgia Law. And he was the director of data services and chief operating officer for elections for the Georgia Secretary of State. For folks who are watching right now, you probably saw him all over the networks. He was the guy that kept calling out Donald Trump during the recount. And he is a Republican. He's a conservative. He's a former Republican office holder. But he believes in the law and in the good faith implementation of the law. And the problem with most voting rights laws is not that the laws are facially designed to discriminate, it's that they're implemented in a discriminatory, arbitrary, and fundamentally unfair manner. So you try and design laws that don't leave open that opportunity. And I think that this is the great challenge, is that when you bring great deal of complexity and the possibility of shenanigans taking place and skullduggery is significantly heightened, and we can't bank on there being a Gabe Sterling everywhere we go where there are laws like this.
So we have about 30 minutes to answer some questions. And the first question from the audience is, what can we expect from the Voting Rights Act in the future then?
Well, the good news is you still have Section 2 of the Voting Rights Act. The difference between it and the provision we've been talking about, Section 5, is Section 2 of the Act allows you or me or anyone who feels like they've been discriminated against in their voting rights to go to court and sue the city, county, or state where they've been discriminated against. The burden of proof is on us to demonstrate that, okay? And the level of scrutiny is actually not too high. The burden of proof is to have it's a disproportionate impact effect rather than being an intent test, okay? So all you have to do is demonstrate discriminatory effect, not discriminatory intent. That's the first thing that's vulnerable though, because that effect standard is set in legislation in 1982. The Supreme Court had briefly articulated to Congress that they needed to apply an intent standard, and that was the 1980 Mobile case. So the first thing that happens is they go after that. The second thing that happens with voting rights under Section 2 is there's an effort to challenge its application to redistricting, that it gets narrowly confined to being applied to the act of voter registration or the act of participating in elections. And now all of a sudden what you do is you start seeing the cracking of minority communities in certain states to ensure that their vote is diluted to the point that it can't have an effect anywhere. Those are the two principal concerns with Section 2, but The biggest problem with Section 2, and this is where, I'll be honest, this is where I made a mistake in 2005 testifying to Congress. I thought that if Section 5 failed, Section 2 would still be a sufficient tool to push back against this. But what happened is between 2005 and 2013, the Confederates kind of came out of the attic in the Republican Party in the South, okay? And we saw efforts to move in a direction that was unanticipated. Just didn't see it, missed it. Section 2 cases only succeed about 1/3 of the time.
Mm-hmm.
Section 5 cases are almost always successful by definition. So, we find ourselves in a situation where we've got a tool, but it's a tough tool to use effectively. It's not up to the task because we've seen the return of bad faith action and indeed a return of illiberalism and anti-democracy, especially in the South, but not exclusively in the South.
So the next question is from Jeanette Jones, and she says, but did not Gabe Sterling also back the new voter suppression laws in Georgia, claiming voter integrity as a reason to support these reforms?
Yeah, and what Gabe is arguing there is he's making an argument that has its foundation in campaign finance law, which is that when the Federal Election Commission was established and the FECA was put in, part of the rationale for defending having the presentation of campaign finance data, making it publicly rendering to public scrutiny was it gave people faith in the process. They knew where the money was coming from. So the argument for voter ID laws is, well, it gives the voter faith that everybody in line is actually a voter and they're all supposed to be there. So yeah, he did that because he is a conservative Republican. He's simply not corrupt. But yeah, he came down on the conservative side of that. Absolutely.
Okay. So a question from Ellen Lurk is that it seems that a number of voting bills in more than 40 state legislatures is of concern to our country, is moving forward the idea that voting is a privilege rather than a right. How do we challenge these proposed statutes? Is there a way to challenge these in the courts? And maybe could you discuss how presenting an ID to vote represses the vote?
Okay. Presenting an ID, let's take the second part first. Presenting an identification to vote by itself does not repress the vote. And if you look at the existing case law on this, in any state where they require voter ID, photo ID to vote, they also have to provide the opportunity to cast what's called a provisional ballot. Okay. Second thing is you can't have a set of onerous burdens attached to voter photo ID to obtain ID to vote. So for example, in Georgia is hilarious this way. They try to put a voter photo ID law in. And what happened is the state was told, well, you can't charge for the ID. So the state said, well, we'll give you a free ID. Then they took the old bookmobiles that the libraries had and turned them into mobile voter ID stations and would go around to people's houses if they called and give them a voter ID. Then what happened is they made it possible that if you didn't have your voter ID, you could actually go and get an in-person absentee ballot in your county, which you didn't have to show an ID to get, and then cast your absentee ballot in person on election day. The thing is, when you get to the point where you're requiring people to undertake a financial burden to get the identification to be able to vote, that's a violation of the 24th Amendment. It's effectively a poll tax. The argument that was made in Texas was the average price for documentation to demonstrate a photo ID in the state of Texas, if you didn't have any of it, was $72. So yeah, that was about 10 years ago, that litigation. And the first part of the question was, what can we do in the 40-odd, for the states are the 40-odd challenges, 40-odd efforts to expand restrictions on voting? You start with state court challenges. Okay, so you go to state court challenge, you look to your state constitution as the basis for challenge. And in doing so, you look for a provision that articulates voting as being a fundamental right. Then you kind of draw in the 24th Amendment as the argument for how this creates a burden that violates federal law. Okay. The alternative is you end up in the federal courts, and my concern in going to the federal court is I have no idea where the Supreme Court is.
Okay.
Yeah. So this is one that I worry about.
So a question, this is more kind of going back in history a little bit. How long did it take for the Voting Rights Act to actually pass through legislation in Capitol Hill when it was first initially introduced?
5 months, 5 months to the day. Well, 5 months from the Selma Bridge event, 4.5 months from the day of introduction. It went very quickly.
Wow.
So the fact that we haven't gotten anything done yet in this Congress shouldn't be that disturbing. Okay. Joe Biden's got a lot on his plate, and he doesn't have nearly the majorities that LBJ had. Yeah.
Okay. So the next question is from Keith and Diane Bystrom. Didn't the Supreme Court in Shelby County versus Holder invite Congress to create a different standard under Section 4?
Yeah, Congress has been invited to restore the trigger. And to be honest, Congress has been presented multiple options. In Rise and Fall of the Voting Rights Act, we articulated, I think, 5 of these, 5 potential coverage formulas. And one of the wittiest, I'm not going to go into detail now, was proposed by Bernie Groffman, one of my other co-authors out of Cal Irvine. And there are many creative formulas that comply with the expectation of the court, but also get to the problem. And the thing we probably need to be talking about is we need to quit worrying so much about restoring the old Section 5 regime per se, and talk about all the things that a new voting law in the US should address, because it needs to be far more general, far more comprehensive, and it needs to encourage a variety of different approaches, not just to the conduct of elections, but actually to how we elect representatives and representative form. But yeah, Congress has been invited. Congress fails to act. This should have been the first thing that was done in 2010 by the Democrats in Congress under the Obama administration. They should have restored the voting rights regime before the 2010 election, and they didn't act on it.
So you had mentioned something that you think should also be a part of this new voting regime. Is I guess I want to call it. You want to just give a little bit more explanation of what that might actually look like on the ground, because I think it really is where we're probably headed with all of this.
I'd say there are a couple of things that need to be done. Is one, well, okay, I'm going to go to my favorite camp, which is redistricting. Congress should use its Article 1 authority to mandate the use of commissions in the crafting of congressional districts, and it should articulate criteria to be applied in the crafting of congressional districts. Congress should also allow states to make use of multi-member districts, provided that they use some form of ranked choice voting or other alternative voting system that captures all the preferences of voters. Okay, so that's one. We could use multi-member districts until the 1840s, and at-large national districts until the 1960s. Mm-hmm. But the idea of having Cook County have 2 congressional districts, and each Chicago district elects 5 members of Congress. You could get you wouldn't have to deal with the crazy district shapes at that point, and you can change the way you approach the map. Okay, so that's one piece. You need to focus on voting practices such as voter caging and efforts to attempt to play gotcha games with voters. Okay. Mm-hmm. Is the second piece. The third thing we ought to think about doing is just making sure that when we issue a Social Security number or Social Security card to somebody, when they turn 16, we issue them one that's also a photo ID. And that is a government identification. And maybe we go ahead and issue everybody a passport also. Just do it right then. So now you've got a completely recognizable, transferable, verifiable identification for every American citizen, right? You take the citizenship issue off the table. You make it go away. You remove the places where shenanigans can take place.
Okay.
Yeah.
So I do want you to kind of offer a little bit of an explanation of ranked choice for people who are not familiar with that concept.
Yeah.
As political scientists, we got beat over the head with it in grad school, but for those of us who are not familiar with it, could you just kind of briefly kind of spotlight that for us?
Okay, well, this is the one neat thing about talking to folks in Nebraska. The odds are pretty good you're a football fan, right? I mean, most consecutive sellouts down there at UNL in college football history. Everybody understands how the AP top 25 is done as a matter of course, right? Who's your number one team, number two, number three, number four, number five, all the way down to number 25. And then we take all the votes of all the people polled in the AP top 25, we assign 25 points to the number one person, 1 point to the number 25 person, and fill in accordingly in the middle. We then sum it all up, and the person with the most votes comes in first. So let's suppose we're using ranked choice voting in an election. We have multiple candidates. What we do is you tell me who is your first preference, your second preference, third preference, so on and so forth. And we assign points to those in inverse order. We sum it all up, and let's suppose we have 12 candidates. We're electing 3 representatives. Top 3 voters get elected. We could also use a cumulative voting system where you're given a vote for a number of votes equal to the number of seats to be filled. You can cast 3 votes for one candidate, 1 vote for 3 different candidates, 2 for one, 1 for another. The idea is to use a system that captures lost information and lost preferences, and you end up getting a diversity of information. The city of New York is using ranked choice voting for all of their elections in the city this spring. Ireland has used a variant on this with multi-member districts for their parliament for nearly a century. The big argument you'll get from election officials is they'll say, oh, the ballot will be too long and voters won't understand, they'll get confused. And the fact is that incumbents don't like it because it breaks their singular relationship between themselves and their constituent. And election administrators don't like it because it's a change of how they do stuff. It's as simple as that. Election administrators are inherently operationally conservative. They don't want to change.
Right.
But that's it in a nutshell.
All right, good. Well, I really appreciate that one. I love that AP poll. That's excellent.
Yeah.
So a question from Mary Yeager. What do Nebraskans need to watch for and do to prevent voter suppression from creeping in here?
Well, the first thing you have to do is you can't buy into the rhetoric that there's electoral fraud. Okay. Well, actually, the best thing you could do is you could clone Ernie Chambers 1,000 times over. That'd be the smartest thing to do. Okay. The defender of the downtrodden is the key to this. But yeah, what you do is you watch for that. You watch for practices at the polls or in county voter registration offices that appear to discriminate, and you call it out. You have to call it out. But the first thing you look for is any effort to frame a reform as being a response to a fraud. Okay. In 10 billion ballots cast that we've audited in the last 40 years, we've found 10 cases of voter impersonation. Yeah. I mean, if we had vaccines that good, we wouldn't worry, right? I mean, it's just an incredibly low rate of voter impersonation. But honestly, the second thing you do is you do ask for election systems, election technology that allows for a paper ballot, allows for a paper trail, and actually mainly just to make voting efficient and convenient. Charles Stewart over at MIT has talked about this, that there's a lot that we can learn about election administration from Disney World. That the ability to put additional kiosks online with paper ballots is a lot faster than putting a new voting machine online and making sure it's programmed. This is something Georgia learned. They've been using touchscreen machines with all their problems. They went to a scan machine with a paper ballot because it allowed them to process voters a lot faster. But the biggest thing we need, honestly, and I'm kind of drifting, is we need professionalized election administration that puts a lot more money into the conduct of elections. We spend more money advertising dog food in the US than we do on election administration.
Great. So a question also asks, would you consider the Voting Rights Act to have been more successful or been open to challenges? Just if you wanted just to give a fair evaluation of how effective it's been.
Okay, so the first wave of the VRA was successful in getting people opening the door to register to vote. But honestly, Motor Voter, the Help America Vote Act actually did a lot more to ensure that people got registered. Okay, so there was general follow-on legislation that made it generally easier to register to vote that helped. But the Voting Rights Act was critical to opening the doors and creating tools to push back against nefarious practices. It was very successful in creating majority representation opportunities in the early 1990s through the creative application of Section 5 of the Act to redistricting by the Bush Justice Department. But all those efforts were thrown out by the Supreme Court, okay? But what it did is it did kind of break the mold a bit and enhanced descriptive opportunities, electoral opportunities for minority politicians and minority voters. But since then, it's largely been a target. It started getting targeted really in 1992. With these efforts to push back against redistricting, creative redistricting efforts. And then with the introduction of these other very creative laws, voter ID law in particular, it's been in a bit of a crouch. Voting Rights Act's been in a bit of a crouch. And there's been kind of a chilling effect on bringing Section 2 litigation for fear of inviting a challenge to the act. And that's, but I'd say, yeah, that's it. But the thing I'd like to just pin onto the end of this is we've had a return of rhetoric that we thought was dead. And it's a nasty, venomous rhetoric, and it went mainstream, and it went mainstream. It's made the Republican Party completely ironic. Completely ironic that the party of Lincoln is the party of the Confederacy. It sounds like something out of that movie CSA. Just, you don't anticipate it.
So this next question from Carter Lucas actually kind of dovetails really nicely with your last response there.
Yeah.
Do you believe that there is a way that we can require voter ID without repressing the vote? And if not, what systems can we use to ensure integrity while making sure all voters get a chance to vote?
Yeah, like I said, just making sure that everyone has ID is one step. I'd say, actually, think about it. Here's where we can get creative. The Roberts Court a couple of years ago in a case on digital privacy determined that your phone is just like your home under the law. Someone has to have a warrant to go into it. They can't access it without your permission, that your phone enjoys the same threshold and castle doctrine. Your phone and your home have the same threshold and castle doctrine. Turning this into a form of identification, because you can already put biometrics on the phone, but the presentation of phone as self might be the solution. That if we can turn digital devices into an undeniable form of digital ID, that could be the key. But oh my God, can you imagine the QAnon response to this? It'll be amazing.
Well, but I think about it, that if you got a QR code, that all you had to do was put your QR code up to a little voter ID thing, and you get a green light and you get to go. I mean, that's how difficult it would be.
Yeah, and that's, I'd say the biggest challenge is we're caught in old thinking.
Right.
We are caught in old thinking rather than thinking in the context of how we do everything else. I just imagine if Bill Clinton had actually gotten healthcare reform through 1993 and we all had a national voter ID card for health, that probably would have qualified as voter identification, the universal health identification card. But we're scared to attack, right?
Right.
Yeah.
Right. So the next question is from Belva Junker. We've got about 10 minutes, so let's want to be conscious of the time here. In states which require ID, but voters cast provisional ballots and voter registration happening at the poll, how does that slow down the official count, or does it?
It doesn't.
Okay.
Yeah. Usually there are very few provisional ballots. Provisional ballots are counted last, but this actually goes to another reform that has nothing to do with VRA, which is we need to be counting and embargoing absentee and early votes as they come in, rather than waiting. And that way, again, it's about knocking off the knucklehead shenanigans that arises from impatience. We have to remind people that sophisticated systems require either the acceptance of the system or the ability to apply sophisticated thinking. And an election is a sophisticated system.
Mm-hmm.
So we're not going to get a result at 10 p.m. on election night. This is, we all went through it. We all saw it. We've all survived to come out the back end. But yeah, no, provisional ballots don't slow anything down.
Okay. So another question from Ellen Lyric.
Yeah.
She said she appreciated being able to drop off her ballot in the ballot box after hours. And she's heard some of the new laws are limiting the number and location of these secured boxes. What is the rationale for limiting the number of these boxes?
I can't give you an intellectual rationale, and I can't speak to the thinking of the lawmakers who voted for it. But I think there's a deep, the motive's partisan. Okay, the motive's partisan, right? The early vote is the blue wave, right? And what happens is, as it comes in, it gets counted after the initial red surge. The blue wave and the blue fade. Yeah, it's all politics. It's all Jonathan, how's the old joke go that if you decide how we get to vote and I decide how we count the vote, I'll win every time?
Mm-hmm.
Yeah. Something funny about that in Colorado, Bob Stein down at Rice, they did a survey experiment, and they discovered that among older voters over 40, because they brought mail-in ballot into Colorado, a majority of them showed up on election day and dropped their ballot off either at their polling place or at a drop box because they like the civic ritual. And that's something I should have brought up earlier. We have to return the civic ritual. And what does that mean? That means that we need to get the practice of voting and the practice of voting with the voting technologies into the hands of kids when they're 6 years old.
Mm-hmm.
Get them the habit of doing it every day so that they know it, so that they are at least functionally literate in how to do it. That to me is the biggest key, that we need to get back to that unifying principle, the civic ritual.
Mm-hmm.
And we've lost that. We've lost it terribly.
Mm-hmm. One of the things I do want to do a shout out to the election officials here in the state of Nebraska. Being a political scientist and watching the demographic transformation that's taken place here in Nebraska, how to reach out to new voters, voters who've just recently become citizens. They've done a remarkable effort here. I'm going to be very honest with you that I have continued to be impressed. And the state legislature has a really quirky law that the governor appoints the election commissioners for where Lincoln and Omaha are. And then everybody else is just like your standard. But in both of those cases, the deputy is always the opposite party. So it's been really interesting for me to watch. But what I do know is that all of them take the process very, very seriously. Mm-hmm. There could not possibly be a sniff of fraud anywhere in this, because, and I found out for myself, I volunteered to become a poll worker a couple of years ago because I just wanted to kind of see the process. You have to go through an extensive, training in order to become a poll worker and receive certification to be able to work at the polls here in Nebraska. So I imagine that in most other states, it's a very similar process.
Yeah, and something we talked about doing here, but we couldn't get organized. Well, Jonathan, you know this, when it's being in the chancellor's office, I'm in the president's office here at OU. There are so many things going on. It's hard to get any one initiative going, right? It's just, we're running around with 1,000 buckets of sand, putting out 1,000 fires on any given day. But we toyed with the idea of trying to get our students activated and trained as poll workers so we can deploy them around the state and incentivizing them, because the problem in Oklahoma is the average poll worker is about 72 years old. Mm-hmm. And under a pandemic in particular, that became a particular concern. But yeah, I think we have to get back to that civic ritual. And the problem is that we confront a situation where not everybody is buying into the notion of philosophically liberal democracy, enlightenment democracy. They become illiberals, they become populists, and populism is not a good word. Okay. not a remotely good word, terrible word for freedom. But we have to get back to that thing, and that's I'm gonna shill this. Kirby Goydell and Nick Davis and I've got a new book coming out of Michigan called How Americans Think About Democracy. It comes out next year, where we're exploring the foundation of this illiberal thought and this anti-democratic thought. And put my kids through college. I've got one in grad school, University of Georgia now. So but give it a look. This is the big challenge. We have to get back to believing in each other.
I think you're right. And so we're going to have to start wrapping it up here. One of the things I do want to really thank you so very much for taking the time to be with us today. I think this has been illuminating for many of us. And I think for me, it also helps to reinforce so many of the things that, I hold near and dear to my heart. One of the things that I continuously challenge myself and challenge others is that, democracy works when we uphold the process in its totality. And I think you've given us a great demonstration of that today. So I'm really appreciative of that. I'd like to bring back Chris Sumerick, our Executive Director for Humanities Nebraska, with some closing comments for us. But thank you so very much, Keith. I really appreciated your time today.
Pleasure to be here. Thank you.
Thank you, Keith, and thank you, Jonathan. I did notice one last question slide in that I really think is striking, because I've heard people ask this question through the most recent election, and it was about concerns about the mass mailing of ballots, if going out in the mail, and whether that was going to lead to any issues. And so just raising the question about not mass mailing ballots out, and just like if people request it or something like that. So I don't know if you have any comment on that area.
No, not really. I'd have to think that one through. There are a variety of canards at work out there in the world in areas of false worry, and I would probably tuck this one in with those. And actually, if I've got 30 seconds, I spent years doing litigation consulting, and probably 2/3 of my clients were Republicans. And I got out in part because I was tired. My politics and the GOP were drifting apart from each other, and I saw this illiberal wave, this anti-democratic wave growing up. And so no matter who your Satan is in politics, on the left or the right, I've probably worked with them at some point in time. So I'm not going to claim purity in this space, but we have to approach this with clear thought and the willingness to change our minds.
I'll add one little point to that. In the state of Nebraska, they will not mail you a ballot unless you actually request it. They will send you a form, or a party will send you a form where you can request the ballot, but it will not be sent to you unless you actually submit that form, and then you'll receive it. And then you have to sign that. And if somebody else says it's fraud, but it doesn't happen that way. So
if that's not Nebraska Practical, I don't know what is.
And truly, there is something to be said for Nebraska Practical. It's something I really appreciate about this state, regardless of anybody's politics, is there's a certain, in the DNA of the state, seems to be independence and careful thinking. And one of the comments that you made, or the term you used about the importance of civic ritual, I also thought that really that doesn't know political lines. You talk to people across the political spectrum, and you get the sense that there's lots of appreciation for the importance of doing your civic duty and having civic ritual. And politics is a messy business and an ugly business, and it always has been. And that's the other reason that's interesting to look at things like the Voting Rights Act and a lot of the things that we study in the humanities. When you look at history, and can kind of take consolation in the fact that it's from day one has been kind of an ugly business at times in politics, and but the importance to democracy of staying informed and engaged as citizens. I mean, that's in the DNA of the state humanities councils and the National Endowment of Humanities, is that's what makes a democracy flourish, is that we all have to stay involved. And so I really kind of appreciated those comments along those lines. So thank you both for your time today. Really, really appreciate this. It's interesting times we're in, and really interesting to look at how history reflects where we are now and where we want to go. So I just want to wrap up by saying, again, Humanities Nebraska is a statewide nonprofit. We appreciate everyone's support of Humanities Nebraska. We're funded in part by the National Endowment for the Humanities, by the Nebraska Cultural Endowment, state funds, and private donations from people all across the state. So we greatly appreciate your support. Please stay just in touch with us, track us on social media, sign up on our website for our updates, email updates on programming coming up. We're really looking forward to getting kind of back more and more in person as things progress. Fingers crossed. It's hard to gather and be in person, in these circumstances, and that's what the humanities have always been about, coming together in person and exploring important issues. And so we're looking forward to that, and still continuing to stay in touch with everybody through channels like this as well. So Keith, Jonathan, thank you again for your time. Thank you, everybody, and I hope you all have a wonderful afternoon.